Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Group of Downing Fry, and I'm joined today by our host Jim York and his guest Celia Deifik, real property lawyer with Lanier & Deifik.
Thank you, Morgan, for the introduction. Well, Celia, how are you today?
I'm great. Glad to be here.
So our viewers that haven't seen you on the show, just give us a little background of yourself.
Sure. I am with Lanier & Deifik downtown in the Capitol Bank building. I've been practicing law in Florida for over 30 years, and I've been board certified in real property law since 1990, recertified every 5 years, and I primarily use that for real estate litigation. If it concerns dirt, I litigate it.
Well, that's something interesting.
A lot of community association litigation over the years, and dispute resolution, because not everything actually goes to court.
Yeah, and that's what we're going to talk about today is community associations, some of the mistakes maybe homeowners make or community associations make, the management companies, and we just want to go over that so we're educating the public about what, what they're doing may be wrong. And then in our second series, we're going to talk about maybe some pending legislation that's in front of our legislators in Tallahassee, okay?
All right. Let me tell you a little bit more background. Very early in my career, I worked with developers to write condominium documents. So I had that kind of background. Then I worked a lot with associations, representing associations. For many years now, though, I have only represented owners who have problems with their community associations. And I may help them with fine hearings, with getting information from their association, with arbitration or mediation, and in some instances with litigation. And I think that the title of my, our conversation today might be not just mistakes people make, but how to save yourself a lot of money on attorney's fees. And I would say the following: if you're an owner in any kind of community association, but let's focus on condo associations for today. Be an educated owner. Become familiar with your own documents and become familiar with the rules that may be promulgated by your board of directors from time to time. And there's always a dynamic balance between the board on the one hand and owners on the other hand.
Right.
I have a lot of respect for people who serve on boards of directors. It's a volunteer job, it's thankless, and it's not that easy. Owners have, on the other hand, legitimate concerns and needs for information. And sometimes these two groups are not communicating well. So what I tell owners is, you have to be familiar with what is going on in your own association. What are the restrictions in your declaration and your bylaws? What are the rules your association has as far as accessing records, videoing or taping board meetings? And the next thing I would say is act in a timely manner. Keep your own records and act timely. I cannot tell you how many times people come to me, they've been angry about something for 15 years.
Right.
And only now has it come to a boil and they want to take action. Well, significant information is no longer available. Associations are only legally obligated to keep records for 7 years. I think we all know that when associations change boards or change property management companies, inevitably something slips through the cracks. And even if the association has a good faith intention to keep their records going back further than 7 years, very frequently records of various types are lost. So if you have a concern even if you're not ready to take action on it yet, ask for these records. Get minutes of meetings. Complain about whatever your issue is timely. Don't file a lawsuit. Write an incident report to your property manager. Write a letter to your board of directors. One of the things that I see is people fail to express themselves in writing and to date it. And that sounds like such a simple thing.
Right.
But in my decades of practice, I cannot tell you how many disputes were lost and lawsuits are lost because nobody dated anything. And nobody had a way of proving that something was delivered. Well, I sent him an email. I never got the email. I made a complaint at the board meeting. There's no record of it in the minutes. So it's not that hard to take a piece of paper, write a letter. Now, so many of us are conditioned these days to do emails and texts.
That's right.
Well, the problem I see with emails and texts is it doesn't force you to sit down and write out all the pertinent points of your issue. If you want to send an email, fine, but write a letter, date it. Date it. And put in the pertinent points, and then, sure, you can scan it and attach it to an email, or if it's a Word document, but it should be signed. It should be also put in the United States mail. Many parts of the condominium statute require that certain things be sent by certified mail. I tell my clients, spend $50 on delivery to save yourself $40,000 later. For instance, if it's important to you, send it by certified mail, return receipt requested. Also send it by a overnight courier, FedEx, UPS, I don't care which one, because then you will get an affidavit from the company that they did deliver it. The other thing you want to do is, let's say you made a complaint, you voiced a concern at a board meeting. And I say, fine, great, let's see the minutes. Oh, well, they didn't put it in the minutes. Well, did you challenge that? If you make a complaint, let's say you and a group of people make a complaint at a board meeting about an issue of legitimate concern, and the secretary of the board omits any mention of it from the next minutes, then write a letter to the president of the board, copy the property manager, if there is one, copy the secretary, whoever it is, and say, gosh, this must have been an oversight. You will recall 10 of us asked about the swimming pool at the meeting on May 15th, and that's not in the minutes. I'd like to see the minutes revised. Even if the minutes do not get revised, by law, the secretary of the association is required to keep your letter in a correspondence file, and you have a record of what happened over the years.
But they're not required to send us the minutes of each board meeting. We have to request that, right?
Well, you can request them. It's very easy to do. And many associations these days have websites where they post these kinds of things. So it's a little easier now. Now, the smaller associations are not required at this point, although they may be in the future, to maintain a website. If you are that upset about an issue, take the steps to follow up and do it timely. Many legal rights are extinguished by time. And sometimes, even though your rights may be actionable, you could file seek an arbitration or file a lawsuit on them. If you don't have the records going back, it makes it that much harder to prove. People die, they move away, memories fade. The best advocate for you is yourself.
True, true.
The other thing that I would say is, you know, I often have people come to me and they've gotten a group of neighbors together because they're exercised about a particular issue at their condominium or neighborhood association. And they come in and they say, we are galvanizing the neighborhood. Here's the letters that we've sent to everyone. Oh my Lord, did you really send these letters? Yes, we did. Well, you need to be prepared to be sued for defamation because you just called 2 of the board members thieving SOBs. Wouldn't it have been better to say, we think there's $50,000 of association monies that are not properly accounted for, and we would like to have an accounting of where they went. So let's talk about getting records. There is a procedure in the condominium statute, in the homeowner association statute, and the corporation statute to request records. Do it in writing. Sign it, date it, and have proof of when it was delivered. Walking into the property manager's office or saying to the treasurer that you met in the parking lot, I need copies of such and such, is not the way to do it. If the association fails, and this is just one minor example, if the association fails to provide those records within 10 working business days, there's a rebuttable presumption that they're willfully withholding them. And if there is litigation or administrative proceedings arising later, the association will not be able to recover their attorney's fees. But there's 100 other examples. So what I tell people is, if you're going to write letters to the board or to your neighbors, make sure you emphasize facts. Do not engage in ad hominem attacks. That's a fancy way of saying, don't say somebody is a lying, thieving wife beater.
Right.
When your issue is what happened to the money. I mean, unless he's been convicted of those crimes, you really don't get very far, and you turn off the people that you're trying to enlist in your cause. If you are going to state something that is your opinion, for instance, this bid was, or this construction contract was entered into without the proper bidding procedure, unless you've really examined all the records or, you know, something, don't write a letter saying they gave it to the president's brother-in-law and they violated the law. You could say, we are concerned that this has not been done in accordance with the statute or in accordance with our declaration, and we would like the board to provide us that proof. So there's a number of things that you can do. You can request records, as we discussed.
Right.
You can send under the condominium statute, you can send a written inquiry to the board. They must respond. They must respond within 30 days. They have 3 options to respond. Let's say your question is, did you get proper bids,
right,
or something like that. Try and make your questions specific, because I've seen people send in letters that are 5 pages and they're all over the place.
Right.
You want to have a very specific, detailed request. The board has 3 options after they get your report, your inquiry. They can give you a substantive response, which means really answer your question.
Right.
They can tell you they're seeking advice from the division, that's number 2, Division of Land Sales in Tallahassee, or that they've sought a legal opinion from the association's counsel. If they seek an opinion from the division, they have to give you that opinion once they receive it within 10 days. If they seek an opinion from an attorney, they have to give you that legal opinion within 60 days from the date of your inquiry. And again, I go back to How can you save yourself money and be your own best advocate? Ask specific questions. If you ask vague, all over the place questions that talk about how, your mother wears army boots, you're likely to get a very vague and ambiguous legal opinion back from the attorney. The other thing that you can do if the board is not addressing a particular situation is if you can get 20% of the unit owners to say, we want the board to address this, and put that in a written petition,
Right.
get the signature of 20% of the voting interest, the board must hold a meeting on that within 60 days. They have to at least get a notice out of a meeting on that, either at the next regular board meeting or a special board meeting. So the other thing I see people do is not take advantage of the internet. People come in all the time and they ask me questions that they could find out themselves in a few minutes on the internet. Were permits pulled? Have you checked with the county permitting department? We understand the association's in litigation and they won't tell us anything. Have you looked on the Collier County Clerk's website or the Lee County Clerk's website? You can find out an awful lot of information either on the website or by going down to the courthouse. So very frequently you can find out the information that you need. The other thing that you can do is when you hear rumors of legislative changes, which we're going to be talking about, I think, in a few minutes, you yourself can go on myflorida.com, go to the House of Representatives or State Senate website. They have all the pending bills, and better, they have the staff analyses of these bills. So the bill might be 50 pages of jargon. The staff analysis is going to be 2 pages of plain English. Why are we doing this? Why are we thinking about doing this?
Well, you've covered a lot, and glad we came up for air.
Okay, sorry.
So, we're going to take a little break here, and
Okay.
I think you covered our last segment because we only have a few minutes left. But
Okay.
We'll take a break, and we'll come back in 1 minute, and we'll
Okay.
finish up what's pending in the legislation right
sure.
now. Okay, thank
Sure.
you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Welcome back. Well, let's finish up this little segment here on what is pending in the legislation.
Well, there's a number of interesting community association bills. And the Condo Bill is essentially a glitch bill. I think everyone is aware that the condominium legislation had a major overhaul a couple of years ago. But there were a lot of things that were very ambiguous in it. So this is going to be an effort to clean those up. For instance, the 8-year term, when does that really start? They're trying to clean that up to mean it starts from when the law was passed and doesn't go back. There's some more substantive changes that the legislature may be addressing. For instance, conversion of the provisions in the condominium statute for arbitration, converting those to mediation. The legislature seems to think that might
be better.
better. Things changing the votes that are necessary for certain actions, changing the regulation of associations a little bit, making them a little bit different than the corporate law, changing the application of some health department regulations to condominium associations, a lot of things.
We were talking about off camera about board members leaving And taking the
records
is,
Sure.
what's happening with that?
Well, there has been a problem over the years with records being defaced or destroyed or lost.
Right.
And one of the things that people were concerned about is board members who would retire or leave because they sold their unit would take records with them, either inadvertently or deliberately.
Right, exactly.
So the law has provided for the last couple of years that they must turn those records over in full within 5 days of the election or leaving the board.
Right.
And if they fail to do so, there's some very serious civil penalties and in some instances criminal penalties for failure to do so or for defacing or destroying records.
And what's the definition of those records that they would be not turning over?
There's a very specific definition, for instance, in the condominium statute of official records. And it's a rather long list and includes the things you would expect: budgets, assessments, minutes, things like that. What people don't realize is you can get other information from the association also. You just have to ask.
Right.
Some of these things are discretionary with the association, but in many instances, they'll give you that information.
Right.
One instance that comes to mind is you're buying a unit and your title insurance agent is concerned because there's an open notice of commencement, because you guys are rebuilding your clubhouse or whatever. So the title insurance company or the buyer might ask for an affidavit of sufficient funds. Are you going to be able to build this?
My question also is that on the board of directors, when they leave or their term's up, we're talking about records, okay? Are they required to keep some records themselves of the minutes or the board meetings themselves, or would they say, well, the management company has that, I have no record
if there
of it?
is a management company, the management company would keep them, but it is the association's responsibility to maintain records within 45 miles of the condominium, or to maintain them in the state of Florida and make them accessible within 45 miles. One of the big problems that we see is that records are constantly lost.
I know.
And that's why I tell people, keep copies of everything. And these days, all you have to do is scan it.
Right.
You don't have to keep a physical file or upload it into the cloud, because this stuff, it disappears.
Right.
It disappears over time.
Well, you did a wonderful job today, and like always, okay? And we covered a lot, and I'm sure it's been helpful for our viewers, and I'm so happy you came and gave us a little update here. And thank you for tuning in. We'll see you next week. Thank you.